Olá, boa tarde a todos. Iniciamos a nossa conferência de encerramento. Meu nome é Fabiana Ventura Piassi, fui a organizadora desse 5º Congresso Brasileiro de Direito do Mar. Foi uma honra ter recebido essa atribuição de ter conseguido reunir tantos palestrantes, tantos convidados. Agradeço imensamente a toda a nossa audiência. Eu queria só fazer algumas breves considerações finais sobre como foi o nosso evento, previamente, à fala do nosso convidado de honra dessa noite. O nosso encontro decorreu excepcionalmente em razão da pandemia, virtualmente. Nós tivemos posso dizer, um sucesso, né, um êxito de participantes. Nós tivemos 2.657 inscrições no congresso, então para nós foi um imenso prazer receber tantas inscrições, saber que tivemos tantos interessados em participar do evento. Eu queria ainda agradecer nesses 2 dias do evento aos renomados palestrantes que contribuíram. Nós tivemos 20 convidados, sendo que foram 10 palestrantes nacionais e 10 palestrantes estrangeiros. Nós tivemos o engajamento de 7 membros da diretoria envolvidos nesse congresso. Nós tivemos a contribuição de 3 colunistas que se dispuseram a nos auxiliar na apresentação das mesas de trabalho. Nós tivemos a apresentação de 10 trabalhos acadêmicos com 19 autores e coautores envolvidos. Então, eu posso dizer com todo o orgulho, com toda a satisfação, que nós tivemos um expressivo número de pesquisadores nacionais, estrangeiros, profissionais, estudantes, que contribuíram sem sombra de dúvidas para o sucesso desse evento. Então, agradeço a cada um de vocês que disponibilizou o seu tempo para passar esses 2 dias conosco. Não vou me alongar em razão do nosso convidado, eu vou passar algumas considerações. A nossa palestra de encerramento será em inglês, com a tradução, e desde então agradeço a todos e vou passar então a algumas apresentações em inglês em respeito ao nosso palestrante. Initially, I would like to thank Dr. Tomas Heidar for accepting the invitation to the closing conference of BILOS Congress. It's an honor for the Institute, and I thank you on behalf of the entire board of the Institute. This year was responsible for coordinating the event, and I would like to introduce you the Institute and the Congress. The Brazilian Institute for the Law of the Sea is a national technical scientific association which brings together academics interested in contributing to the development of law of the sea in Brazil, and which recognize the relevance of the debate on issues related to the sea in various aspects. This year, we proposed it as a central theme for the 5th Congress of the BILOS, a dialogue on current marine and maritime public policies. The Congress was organized considering the need to update the national maritime policy that is from 1994 in view of a new international and domestic agenda on issues related to the sea and oceans. We consider also the institution of an interministerial working group whose purpose is to prepare proposals for the reformulation of our national maritime policy. We consider the need to align a new policy with the 2030 agenda of the United Nations, and in addition to other international instruments related to the sea. In addition Now, in addition to this initiative by the federal executive power, we considered other initiatives in the legislative power for normative change. And we considered the indispensability of debating these issues in the light of the national, the comparative, and the international law. So the Congress brought together researchers, professionals, authorities, and students, both national and foreign, in order to promote debates on related issues in the law of the sea. And I can say proudly that today we promoted the most important and expressive event in the area of the law of the sea in Brazil. Finally, I would like to thank our guest and everyone who participated in the event, and all the technical staff and members of the IBDMA board. I'm very proud and satisfied with the organization of this Congress. So I would like to call Director Luciana Fernandes Coelho to introduce our guest, Tomas Heidar. Thanks a lot for accepting our invitation, dear Tomas Heidar. Luciana.
Thank you very much, Fabiana. I'm very honored to introduce you today to Dr. Tomas Heidar, who is a judge of the International Tribunal of the Law of the Sea since 2014. He is also a director of the Law of the Sea Institute of Iceland since 2000, and a co-director and lecturer at the Rhodes Academy of Oceans Law and Policy since 2003. Judge Tomas, you have the floor.
Thank you very much for the introduction, ladies and gentlemen. I would like to thank the organizers, in particular, Andre de Paiva Toledo and Tiago Sanella, for inviting me to give the closing address here at the 5th Congress of BILOS. I have noticed the growing activities of the Brazilian Institute in recent years, and I'm very pleased to address you today. It is actually evening here in London where I speak, and there is no better way to start a Friday evening than with a lecture. I note with great satisfaction the launch at your Congress yesterday of the book, International Fisheries Commissions in honor of Professor Fabio Hassin. I was truly honored to write a tribute in the book to my friend Fabio, and I hope to have the chance to visit Brazil in the near future to honor his memory more directly. As you know, Fabio touched many people, and I have fond memories of him from places such as New York, Rome, Rhodos, Brasilia, and Recife. Ladies and gentlemen, on 1st October 1996, the International Tribunal for the Law of the Sea, ITLOS, held its inaugural meeting, its first meeting in Hamburg. Therefore, 1st October last, 2021, marked its 25th anniversary. On this occasion, I thought it appropriate to reflect on the tribunal's jurisprudence through these 25 years. I will focus on some of those areas where ITLOS has, in my view, added legal clarity and thus contributed to the development of the law of the sea and related international law. Let me check my PowerPoints.
Judge Thomas, do you need help?
I think it's okay. I'm just I'm trying to find the right PowerPoints. I thought I had them here. Here we go. Here we go. I'm sorry about that. So, as you all know, the main task of ITLOS and also the other courts and tribunals under the Law of the Sea Convention is to settle disputes concerning the interpretation or application of the convention. However, in some cases, in actually quite many cases, courts and tribunals have also the opportunity to clarify and develop the law of the sea, which not only benefits the parties to the relevant dispute, but also the international community as a whole. This applies in particular to provisions that are vague or ambiguous, or which include undefined terms, which is sometimes the result of difficult compromises that various groups of states with different views and interests have reached at the Third Law of the Sea Conference. In such cases, it is sometimes left to courts and tribunals to clarify the provisions and give them content. And there is quite a typical example of this, which is Articles 74 and 83 of the Convention relating to the delimitation of the EEC and the continental shelf. Very vague provisions, but they have been clarified through the decades by courts and tribunals. But I will try to give you some similar examples from the jurisprudence of ITLOS. Now, ITLOS has dealt with 27 cases during its 25 years and now has further 2 cases on the docket, so altogether 29 cases. It's interesting to note that of its first 15 cases up to 2007, 13 out of those 15 were urgent proceedings, that is 9 prompt release cases and 4 provisional measures cases. In recent years, however, the judicial activities of the tribunal have diversified and included a number of cases on the merits, in particular concerning maritime delimitation or the arrest and detention of ships, as well as 2 advisory opinions. Let me now focus on some of those areas where the tribunal has, in my view, added legal clarity and thus contributed to the development of the law of the sea. Up to 2007, as I said before, ITLOS heard 9 applications for prompt release of vessels and crews, including its very first case, the MV Saiga case from 1997. However, quite interestingly, since 2007, no prompt release case, not a single prompt release case, has been referred to ITLOS. And one may wonder why that is the case. This may possibly be explained by the fact that the tribunal has developed comprehensive jurisprudence on various issues that may arise under Article 292 of the Convention on Prompt Release and clarified those issues. For example, in the Kamuoka case of 2000, the tribunal listed the relevant factors for determining a reasonable bond or other financial security. It is also worth noting that all the 9 prompt release cases submitted to the tribunal before 2007 have concerned vessels arrested for fisheries offenses. The tribunal is yet to receive an application for prompt release of vessels detained for alleged violation of legislation for protection of the marine environment, as is provided for in the Convention. The tribunal has dealt with 3 cases on the merits where the flag state claimed compensation for damage arising from the arrest and detention of the ship in question. Those are the MV Saiga No. 2 case, the MV Virginia G case, and the MV North Star preliminary objections case. In all of these 3 cases, the respondent, which is typically the coastal state, filed several objections to admissibility of the flag state's claims. The objections to admissibility were inter alia based on, first, the nationality of claims, and second, the rule of exhaustion of local remedies. These are fundamental questions because if they are accepted, such objections terminate the proceedings before the merits of the case are examined. Now, looking first at the nationality of claims, where we have the famous notion of ship as a unit. In the MV Saiga No. 2 case, the tribunal clarified the unique nature of a ship as a unit, a finding that has a particular relevance for the right of the flag state to seek redress for the ship's crew members who are not its nationals. The tribunal stated that the Convention considers a ship as a unit as regards the obligations of the flag state with respect to the ship and the right of a flag state to seek reparation for loss or damage caused to the ship by acts of other states. Thus, the ship, everything on it, and every person involved or interested in its operations are treated as an entity linked to the flag state. The nationalities of these persons are not relevant. In the subsequent 2 cases, MV Virginia G case and MV North Star preliminary objections case, the tribunal reaffirmed its jurisprudence with similar wording as in the Saiga case. Now, turning to the rule of exhaustion of local remedies, in all of these 3 cases, the tribunal also addressed the question, what is the nature of an injury to a ship resulting from the relevant internationally wrongful act? The question is whether it is A, an injury to persons with interest in the ship, or B, injury to the ship's flag state, so-called direct injury. The answer to this question has an implication for the applicability of the rule of exhaustion of local remedies stipulated in Article 295 of the Convention. In all 3 cases, the tribunal concluded that there was direct injury to the flag state and that the rule was therefore not applicable. Consequently, in all 3 cases, the tribunal rejected the aforementioned objections to admissibility of claims and examined the merits, including claims for reparation or compensation. Now, turning to the protection of the marine environment, the tribunal has dealt with a number of environmental cases and contributed to the protection of the marine environment. This has primarily occurred in the context of proceedings for the prescription of provisional measures and in advisory proceedings. it should be noted that one of the relevant grounds for prescribing provisional measures is to prevent serious harm to the marine environment. This is stated in Article 290 of the Convention. Provisional measures proceedings may be particularly useful in the context of environmental cases, where there is a need to act promptly to avoid further deterioration of the marine environment, for example, marine pollution or depletion of a fish stock. It has been commented that ITLOS has reaffirmed and developed the basic principles of Part 12 of the Convention relating to the protection of the marine environment, including the precautionary approach, the duty to cooperate, the duty to conduct environmental impact assessments, EIA, and the duty of due diligence, thereby contributing to the development of international environmental law. It has also been stated that the Tribunal has demonstrated its willingness to interpret and apply Part 12 of the Convention consistently with the contemporary state of international environmental law. Turning to the Tribunal's environmental jurisprudence, the first point to make is that it has not taken a narrow view, but rather a broad view of what is meant by the marine environment. In its 1999 order in the southern bluefin tuna cases, the Tribunal stated that the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. In its 2015 advisory opinion, the Tribunal had to provide a legal basis for the due diligence obligation of the flag state to take measures to prevent vessels flying its flag from engaging in IUU fishing in the exclusive economic zones of other states. Faced with the fact that the Convention does not include any provisions that refer explicitly to flag state obligations with respect to IUU fishing, the Tribunal found support inter alia in Articles 192 and 193 of the Convention, and then referred to the aforementioned dictum from southern bluefin tuna. In its order in that same case, the southern bluefin tuna case, the Tribunal relied on the notion of prudence and caution to ensure that effective conservation measures are taken to prevent serious harm to the stock of southern bluefin tuna. In the subsequent MOX plant and land reclamation cases, the Tribunal also referred to the notion of prudence and caution to support the view that it was urgent that parties conform to the principle of cooperation, and the same approach was later followed in the MV Louisa, Ghana, Cote d'Ivoire cases, both regarding provisional measures. Building on this, in its 2011 advisory opinion, the ITLOS Seabed Disputes Chamber recognized that a trend had been initiated towards making the precautionary approach part of customary international law. The notion of environmental impact assessment was included in the southern bluefin tuna, MOX plant, and land reclamation provisional measures cases. The two last mentioned orders, the MOX plant and land reclamation, appear to show that provisional measures can be used as a judicial tool to enforce the obligation to carry out joint monitoring and environmental impact assessment, which are a prerequisite to protect the marine environment. The principle was most significantly addressed in the 2011 advisory opinion of the Seabed Disputes Chamber, which stated, it should be stressed that the obligation to conduct an environmental impact assessment is a direct obligation under this convention and a general obligation under customary international law. The Tribunal has furthermore substantiated the general norms concerning the protection of the marine environment laid down in Part 12 of the Convention by construing from them a duty to cooperate. In the Southern Bluefin tuna cases, the tribunal emphasized the need for greater cooperation between the parties to ensure conservation and optimum utilization, and it ordered the parties to resume negotiations for that purpose without delay. In the Mox Plant case and later in the land reclamation case, the 2015 advisory opinion and the Ghana Cote d'Ivoire provisional measures case, it was stated that the duty to cooperate is a fundamental principle in the prevention of pollution of the marine environment under Part 12 of the Convention and general international law, and that rights arise therefrom which the tribunal may consider appropriate to preserve under Article 290 of the Convention. And finally, under the environmental jurisprudence, the duty of due diligence in the context of the protection of the marine environment may be seen as an underlying duty which is closely related to the aforementioned environmental principles, the principles that I've just mentioned. In their advisory opinions, the Seabed Dispute Chamber and then the tribunal have clarified the content and application of the duty of due diligence. In the 2011 advisory opinion, the Seabed Dispute Chamber stated that the obligation to ensure compliance by sponsored contractors with the terms of the contract and the obligation set out in the Convention and related instruments is an obligation of due diligence. The Chamber then clarified that the obligation to ensure is an obligation to deploy adequate means to exercise best possible efforts to do the utmost to obtain a result. It is an obligation of conduct and not an obligation of result, and it is an obligation of due diligence. The 2015 advisory opinion on IUU fishing addressed in particular the obligation of the flag state to take measures to prevent vessels flying its flag from engaging in IUU fishing in the exclusive economic zones of other states. Drawing on the 2011 advisory opinion by the Seabed Disputes Chamber, the tribunal concluded that this is an obligation of due diligence. In my view, the 2015 advisory opinion serves as a guideline for coastal states to assess the performance by flag states in complying with their due diligence obligations with respect to IUU fishing, and to take legal action against non-complying flag states as appropriate. In 2012, the tribunal delivered a groundbreaking judgment in the dispute concerning the delimitation of the maritime boundary between Bangladesh and Myanmar in the Bay of Bengal. Not only was this the first maritime delimitation case of the tribunal, but it was also the first international judicial institution to delimit the boundary between the parties' respective continental shelves beyond 200 nautical miles. In its judgment, ITLOS delimited three maritime areas. First, the territorial sea. Second, the EEZ and the continental shelf up to 200 miles. And third, the continental shelf beyond 200 miles. Both Bangladesh and Myanmar had made submissions to the Commission on the Limits of the Continental Shelf, the CLCS, but it had not yet considered the submissions due to lack of consent by the parties. However, the tribunal found that it had jurisdiction to delimit the continental shelf in its entirety, both within and beyond 200 miles, and that it was appropriate to exercise that jurisdiction in this case. And then the tribunal explained why it considered it appropriate to exercise jurisdiction. it stated that it would have been hesitant to determine entitlement to and proceed with the delimitation of the area beyond 200 miles if it had concluded that there was significant uncertainty as to the existence of a continental margin in the area. However, the tribunal noted that the Bay of Bengal presented a unique situation, as acknowledged in the negotiations at the third conference, where a special solution was found for the outer limits of the continental shelf in the Bay of Bengal, and that it was satisfied, the tribunal was satisfied, that there is a continuous and substantial layer of sedimentary rocks extending beyond the 200-mile limit. The tribunal then applied the same method as within 200 nautical miles and continued the delimitation line beyond 200 miles until it reaches the area where the rights of third states can be affected. The tribunal furthermore clarified the existence of the so-called gray area, which is the unavoidable consequence of adjusting the provisional equidistance line when delimiting the continental shelf beyond 200 miles between states with adjacent coasts. This problem does not arise when delimiting the shelf between opposite coasts, but it is relevant when dealing with states with adjacent coasts and whenever the provisional equidistance line is adjusted. If the equidistance line is followed, there is no gray area, but as soon as it is adjusted, there will be a gray area. In this case, the tribunal adjusted the provisional equidistance line in favor of Bangladesh because of the concavity of the coastline. And the gray area is within 200 nautical miles from Myanmar, but it is also on Bangladesh's side of the boundary line. So the tribunal clarified that in the gray area, Myanmar has EEZ rights, exclusive economic zone rights, over resources in the water column, and that Bangladesh has continental shelf rights over resources on the seabed, continental shelf resources. The 2019 judgment of the tribunal in the MV Northstar case offered a rare opportunity to clarify the freedom of navigation under Article 87 of the Convention. It is not common, it's very uncommon that freedom of navigation is dealt with by courts and tribunals. The tribunal stated that it goes without saying that physical or material interference with navigation of foreign ships on the high seas violates the freedom of navigation. It added, however, that even acts which do not involve physical interference or enforcement on the high seas may constitute a breach of the freedom of navigation. The tribunal further stated that any act which subjects activities of a foreign ship on the high seas to the jurisdiction of states other than the flag state constitutes a breach of the freedom of navigation, except in exceptional cases expressly provided for in the Convention or in other international treaties. The tribunal held that the principle of exclusive flag state jurisdiction prohibits not only the exercise of enforcement jurisdiction on the high seas by states other than the flag state, but also the extension of their prescriptive jurisdiction to lawful activities conducted by foreign ships on the high seas. In the view of the tribunal, if a state applies its criminal and customs law to the high seas and criminalizes activities carried out by foreign ships thereon, it would constitute a breach of Article 87 of the Convention, unless justified by the Convention or other international treaties. According to the tribunal, this would be so even if the state refrained from enforcing those laws on the high seas. Turning now to the term disputes concerning military activities, In the 2019 case concerning the detention of 3 Ukrainian naval vessels, provisional measures, between Ukraine and Russia, the tribunal had to interpret the term disputes concerning military activities, which may be exempted from compulsory dispute settlement under Article 298(1)(b) of UNCLOS, the convention. Both Ukraine and Russia had made declarations under that provision and exempted disputes concerning military activities from the compulsory dispute settlement mechanism of UNCLOS. The question was whether the dispute concerned military activities, in which case the prima facie jurisdiction of the Annex 7 Arbitral Tribunal dealing with the case on the merits would not be established, or rather whether the dispute concerned law enforcement activities, in which case such jurisdiction might be established. The tribunal stated, firstly, that the distinction between military and law enforcement activities cannot be based solely on whether naval vessels or law enforcement vessels are employed in the activities in question. And this is because in so many activities by states, they are using naval vessels or law enforcements, even both types in the same activity. So it is difficult to base the distinction on whether one uses this type of a vessel or the other type. Secondly, the tribunal stated that the distinction between law enforcement activities and military activities cannot either be based solely on the characterization of the activities by the parties to a dispute. And this is, I should note that this is somewhat different approach than the Annex 7 Arbitral Tribunal took in the South China Sea Award. And thirdly, the tribunal said that the distinction must rather be based primarily on an objective evaluation of the nature of the activities in question, taking into account the relevant circumstances in each case. The tribunal then examined the relevant circumstances in the case and concluded that they had suggested that the arrest and detention of the 3 Ukrainian naval vessels by Russia had taken place in the context of a law enforcement operation. So the tribunal found that the Annex 7 Arbitral Tribunal would have a prima facie jurisdiction, and the tribunal ordered the release of the naval vessels and their crew. It is interesting to note that currently the issue of jurisdiction is being addressed by the Arbitral Tribunal, which is dealing with the case on the merits. And here is finally a recent example from this year of a legal clarification that goes beyond the law of the sea. It concerns the legal effect of ICJ advisory opinions by the International Court of Justice. In its judgment of 28 January this year, a special chamber of ITLOS found that it had jurisdiction to adjudicate upon the dispute between Mauritius and the Maldives concerning the delimitation of the maritime boundary between Mauritius, or the Chagos Archipelago more precisely, on the one hand, and the Maldives on the other hand, in the Indian Ocean. And on this picture, you see the biggest of the islands that make the Chagos Archipelago. The Maldives had submitted a number of preliminary objections to the jurisdiction of the Special Chamber of ITLOS in this case, in particular on the basis that there was a dispute between Mauritius and the United Kingdom regarding sovereignty over the Chagos Archipelago. According to Article 288, paragraph 1 of the Convention, a court or tribunal has under the Convention jurisdiction over any dispute concerning the interpretation or application of the Convention. Clearly, a territorial sovereignty dispute is not such a dispute. The key question was therefore whether or not a sovereignty dispute existed over the Chagos archipelago. The Special Chamber based its findings in particular on the advisory opinion of the ICJ from 2019 on the legal consequences of the separation of the Chagos archipelago from Mauritius in 1965, which had been requested by the UN General Assembly. In its judgment, the ITLOS Special Chamber noted that advisory opinions of the ICJ cannot be considered legally binding. However, it added that it is equally recognized that an advisory opinion entails an authoritative statement of international law on the questions with which it deals. It stated that judicial determinations made in advisory opinions carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law. And here, obviously, the Special Chamber was referring to the ICJ as the principal judicial organ of the United Nations. Now, it is interesting to note that the legal effects, what the Special Chamber said about the legal effect of advisory opinions is consistent with the separate opinion of Judge Rosalind Higgins in the Wall case, the advisory opinion in the Wall case. If you want the reference, it is paragraph 38 of her separate opinion. The Special Chamber stated that the determinations made by the ICJ with respect to the issues of the decolonization of Mauritius in the Chagos advisory opinion have legal effects and clear implications for the legal status of the Chagos archipelago. The Special Chamber concluded that the United Kingdom's continued claim to sovereignty over the Chagos archipelago is contrary to those determinations, and Mauritius' sovereignty over the Chagos archipelago can be inferred from the ICJ's determinations in the advisory opinion. The Special Chamber thus found that the dispute concerning sovereignty over the Chagos archipelago had been disposed of by the ICJ in its advisory opinion. Since the ITLOS Special Chamber rejected all the preliminary objections of the Maldives and found that it had jurisdiction to deal with the case on the merits, the written proceedings of that part of the case have been resumed. Let me finally say a few words about what I anticipate could be some of the areas where the tribunal might be called upon to pronounce in the future. It's always difficult to predict about the future, but let me just mention a few areas where I think the tribunal might become active. In addition to, of course, the traditional areas such as arrested detention of vessels and so on. So the first area that I would mention is delimitation and delineation of the continental shelf beyond 2 nautical miles, including jurisdictional aspects. ITLOS has already dealt with 2 cases on delimitation of extended continental shelf, and it is now dealing with the 3rd case. And the arbitral tribunals and the ICJ have also dealt with a few cases on delimitation, and there are more in the pipelines, so to say. There has been no case yet on delineation, the determination of the outer limits of the continental shelf vis-a-vis the international seabed, but it will be interesting to see whether such cases will also appear in the future. IUU fishing is still very much an ongoing activity, which of course is of concern. As I mentioned earlier, I believe the advisory opinion of the tribunal from 2015 provides a guideline for coastal states to assess the performance of flag states and to take legal action as appropriate. Thirdly, of course, very much a big issue. The Glasgow conference is just about to finalize, I believe. So this is really in the headlines. And this is also very relevant in the law of the sea. Climate change and oceans are very much related. And in particular, the legal effects of sea level rise as a consequence of climate change on baselines and limits of maritime zones. So the tribunal could possibly be called upon to pronounce on that issue either in the form of an advisory opinion or in a contentious case, in a case with a dispute between states. I would also mention deep seabed mining. As you know, the International Seabed Authority is currently developing the mining code. The focus has been on exploration. Now it is turning to exploitation. And so I believe there may be cases in the future, in the near future, regarding deep seabed mining, and it could possibly include impacts on the marine environment, which is very much debated these days. I would also mention the BBNJ issue, conservation and sustainable use of biological diversity of areas beyond national jurisdiction, BBNJ. As you know, a new implementing agreement is being negotiated under the convention on this issue, and it is quite probable that ITLAS will be given some special role under that convention to deal with disputes or to receive requests for advisory opinions from the conference of the parties of the new treaty. So obviously the tribunal in Hamburg is monitoring and watching very well the progress in those negotiations. And finally, I would just mention as a very final point that since many cases are, and including those that I have mentioned, are becoming increasingly technical and scientific, I believe that there will be a more need for a recourse to scientific and technical experts to deal with very complex cases in terms of technology or science. And among the options there is Article 289 of the Convention, which provides for the option of courts and tribunals to nominate either ex officio or at the request of the parties 2 or more scientific experts to sit with the tribunal, to take part in all the deliberations, and to assist the judges in those complex issues, but of course without the right to vote. So I would make that my last point, and thank you very much for your attention.
Thank you very much, Judge Tomas. It was a very, very insightful review of the work of the tribunal. It's impressive how you could put in such a short time frame all the work and the valuable contribution to the law of the sea that the tribunal has been doing over the years. I would like to highlight the last advisory opinion on the legal effects of an ICJ advisory opinion. I think that one for me was very interesting, all the remarks that the tribunal had on that particular one. And I would also like to highlight that some of the points that you have pointed in the looking ahead part of your presentation are very timely and very in accordance with the present conference that we have organized. For instance, in this week, we hosted a moot court, and our moot court was about a case that involved, so it was a case under the competence of the tribunal involving marine pollution and IUU fishing and small island developing states. So some of the topics that you highlighted were brought by the moot court tribunal on that particular case and may be brought by the tribunal in the real life. As well, As you mentioned, the recent conference, the climate change conference in Glasgow, some good outcomes of it is the creation of the Commission of the Small Island Developing States on Climate Change by Antigua and Barbuda and Tuvalu. And this commission would give the tribunal the competence to, or would have the competence to request advisory opinion to the tribunal. So yes, it is a point that is in your notes, and we are very excited, and I can say that on behalf of all the institute, that we are very excited to see how this is going to play in the tribunal in the future. I'd like to give the floor now to Fabiana, so she can move with our event.
Thanks a lot, Luciana, and thanks a lot, Judge Thomas. It was a wonderful class for our students and for our audience. We're very proud to hear you this evening. I just have one question about climate change. If we should have hope with the conference in Glasgow, and what we can expect about the job of the ITLOs, including the legal effects of the sea level rise. If you could anticipate us the mentality of the tribunal in this issue. Thanks.
Thank you very much for your positive remarks. So obviously I was not in Glasgow, but actually my wife was. She just turned back to London from Glasgow. She was representing Argentina. She's a diplomat for Argentina. So most of my knowledge from that conference comes from her, actually. But I think, so I wouldn't really want to comment on the conference there, but I would just say that there are obvious links between climate change and the oceans, and they are manifold. There are negative consequences. So you could look at climate change as marine pollution in that sense. There are negative consequences for the ocean because of climate change. And obviously the most visible consequence is the rising of sea level, which may affect baselines and possibly limits of maritime areas. And there are many different schools of thoughts on how that should be dealt with. There is also the question of the most dramatic cases with disappearance of islands, which actually would go beyond the law of the sea, because that really touches upon statehood. You know, what constitutes a state? Do you need land territory to be a state? And that is really a public international law issue where the tribunal would not have jurisdiction to engage in that. But broadly speaking, I think the tribunal would very much have jurisdiction to deal with the question of the rise of sea level and the consequences for baselines and maritime limits and so on. But obviously, I really cannot comment on it, because being a judge means that you cannot make any substantive comments on what is the solution. But I think in the literature, obviously, many different pathways have been discussed, in particular by the states that are involved, the small island developing states that are very vulnerable. And I mean, they have discussed, obviously there is now, this issue is being dealt with now by the International Law Commission, which actually just held its elections. And before that, the International Law Association also dealt with this issue, and they made some recommendations. These states also have considered developing state practice, which would be favorable to them, and to seek, you know, approval by the rest of the international community for whatever practice they wish to develop. So there are many different procedural aspects here, and in addition to those substantive ones. But I would just say that the tribunal is ready to act upon a request or to receive contentious cases in this area as in other areas. But I think there is a remarkable number of new law of the sea issues that I try to point out in my last slide. And obviously it is always interesting to deal with cases, but I think these new cases would be particularly interesting for not only for the judges, but also for the academia and practitioners and so on. So one can only hope that we will get active in some of these areas in the near future. I'm sorry, I cannot really say much more than that.
Thanks a lot. This matter concerns me because my city in Brazil is an island. so this is why I asked you. Thanks a lot. I think that we're coming to an end to our Congress. It's time to finish our job. Thanks a lot, Judge Tomas, for your attention here. I'd like to thanks to all our body that worked in this Congress. And Luciana wants to, oh, okay. You're free.
Just before you move to the end and you close the panel, as Judge Tomas just mentioned, the elections, the ILC elections, I think we would also seize this opportunity to congratulate Professor Jorge Galindo, Bandeira Galindo, that has just been elected as the Brazilian representative in the ILC. So I think it's an opportunity to congratulate him. He was supposed to be participating in our conference. He's a very close ally. He has been my supervisor in my master's in Brazil, and he was the one sponsoring me to study law of the sea. So he is very knowledgeable on this subject.
Excuse me, Fabiana. May I make a question to the Judge Heidar? I'd like to enjoy this moment. I have a curiosity about ITU's jurisprudence. I promise I will not take one time, but I'd like to know about the Judge Heidar, because the United States are not party to UNCLOS. But in the case 21 of ITUS, this state intended to participate in the advisory opinion procedure. I'd like to know if this written unilateral manifestation of the United States could correspond in some way to an acceptance by a third state of some obligations provided in UNCLOS, pursuant to the Vienna Convention on the Law of the Treaties. Would it be possible, or it's, what do you think about this possibility of United States being accepted UNCLOS obligations, even if it's not a party of the convention?
I'm not quite sure I understand fully the question. So I think the fact that the United States was allowed to make a submission to the tribunal in case 21, I think it relied on the fact that the United States is a party to the UN Fish Stocks Agreement. And so because the question regarded issues that are partly dealt with by the UN Fish Stocks Agreement, there are really no specific flag state obligations set out in the Law of the Sea Convention on IUU fishing, whereas the UN Fish Stocks Agreement in Article 18 has very detailed flag state obligations, and some of them apply also not only on the high seas but also in the EEC. So I think, and if you look at Judge Peck's separate opinion in that case, which I think always was very well, very thoughtful, I think, so there was a logic in allowing the United States to make a submission, even though they are not parties to UNCLOS, because they are parties to the UN Fisheries Agreement. And I don't see any connection with their participation in that case and a possible commitment to UNCLOS. So I'm not sure I understand your question, but on the other hand, the United States has stated, I know this from my earlier life, where I was legal advisor for Iceland at the UN and so on, that the United States has on several occasions stated that they recognize at least most of the provisions of UNCLOS as customary law, and therefore consider themselves bound by it, even as non-parties to the convention. But let me just make one point which I think may be relevant here, and if you are looking at the jurisdiction of the tribunal to deal with cases with a non-party involved, so like the United States, then it is quite clear that obviously the main task of the tribunal is to deal with disputes between states parties to the convention, between state A and B. They are both parties to the convention, but you could also have a state A that is a party and a state B that is a non-party if state B accepts the jurisdiction for that specific case. So it's ad hoc, basically, approval of the jurisdiction for that specific case. So the tribunal can also deal with disputes involving non-parties to UNCLOS if they approve the jurisdiction on an ad hoc basis. I hope I somehow responded to what
yes,
you were.
Yes, of course. It's a provocative question. Thank you very much, Judge Heidar.
Thanks a lot, André and Luciana, for your considerations, and Judge Thomas for the answer. And I'd like to call our president of the institute that has just arrived, Dr. Thiago Zanella, to finish our conference. So Thiago, the word is yours.
Thank you very much, Fabiana. And thank you very much, Judge Tomas Heidar. I was watching in YouTube your presentation, and it was beautiful. It was a real class for us. And I appreciate and thank you very much for our time here with us. And it allowed me, I just want to speak briefly with our audience in Portuguese in Brazil, just to finish our Congress. Thank you very much, Judge Thomas.
Thank you very much. Thank you.
Muito obrigado a todos. Então, pessoal, eu só entrei aqui para realmente finalizar o nosso congresso como presidente. É meu último ano presidente do IBD. Então, eu queria estar aqui com vocês no encerramento das atividades do 5º Congresso, que foi organizado pela Fabiana, e eu queria agradecer a Fabiana também pelo belo trabalho, pela organização. Não é fácil, eu sei muito bem que não é fácil essa organização, é um trabalho constante, é um trabalho extremamente cansativo, né? Eu já cheguei a ficar doente nesse congresso de tanto trabalho, que realmente é bastante extenuante, e o congresso foi, sem dúvida nenhuma, muito bem organizado. Eu queria aqui publicamente agradecer a Fabiana, e nesse momento, então, como atual presidente ainda do Instituto, declarar encerrados os trabalhos desse 5º Congresso do Instituto Brasileiro de Direito do Mar, e agradecer a todos da diretoria que ajudaram a organizar, todos os estagiários que ajudam o Instituto, que trabalham no Instituto, todos os colunistas que não podem ser esquecidos, que trabalham também muito pelo Instituto, e todos trabalham, é um trabalho voluntário, né, de todo mundo, que demanda bastante tempo e esforço, e eu gostaria de também agradecer a todos os envolvidos no Instituto, né, que tem trabalhado aí durante esse ano com muitas atividades e muito trabalho. E, mais uma vez, muito obrigado. Então, por as nossas atividades do 5º Congresso Brasileiro de Direito do Mar.